So what I'm saying, that's what we mean by two lawyers never agreeing on one point. Yes, this one has a different view, the other one has another. So he has quoted his, that's Chiaibua, meaning that that's how he would have dealt with it, right? But he's not the judge. That's the unfortunate situation. So in the democracy, he's allowed to hold his opinion.
We are being told that when a charge sheet is defective, that defectiveness should be overlooked. Proceed. My Lord Justice Kpega, in his validatory judgment of Sekwejo II and the Republic, said the provision you read relates to Act 30. However, the 1992 Constitution has raised particularity relative to charge sheet to a constitutional pedestal. Article 19, 1D. And for that matter, where particulars are defective, you cannot use evidence to cure that defect. And so if you look, Sedi had two appeals. When prosecution called its 6 witnesses, the prosecution said they have closed their case.
Sedinam tamako ni reason de obi e kan wasem obi a de no hagem a wokabi na ene ukupi TV3 ene the point eswa and I say the key points in so program no moye no hosted by for can say na just a pandit na nyasem keto umedi nkomo papa na yebedwe ne feed no obi a sorry a no de na di aba enye say lawyer Marti Kpebu ene invited a guest no more program no sankasa no penny berry iti bedwe no feed no ya kwakutie the support o key points on TV3 so na the reason why ntia ma ye release your mama no said na temeko no ye di hunkomo again the reason your mudina so ejele no and the reason and this aban so gina so also release your mama no and also any issue and so a poppy babti busia e be di akire update be bia no is also edebebro.
If you look at section 406 of Act 30, okay, it clearly brings to question what the justices of the appeal court did. Okay, and 406 generally talks about substance and not form. That you don't just throw out everything because there were errors in, certain things, and it doesn't go to the substance. And in one of the statements, I kind of gleaned that the justices were making the suggestion that it goes to the substance. And I was looking for where it goes to the substance. And I didn't see it. So for you to say they did a sloppy job and the job was so sloppy that the crime didn't happen. Okay, I think that if you flip the other side, yes, they have to prove beyond reasonable doubt. But for you to also take it up and throw everything away, you have to prove, at least to reasonable people, that everything that was done was wrong. Look, one charge alone is enough to put a person in jail. Okay, so to suggest, and by the way, she has been acquitted and discharged. Okay.
Which means that any other charge is completely
okay.
Out.
Now, if you put all of, I said, don't ignore a trend. If you put the sweepiness of the action, everything gone. If you put some of the things that were done, it looks like somebody wanted to just free Sedinam. And then you connect it to the things that were said before she came. You ask yourself, where are we going with this corruption thing? What signal does this thing send? So for me, look. Let's see how the appeal will go. But I can tell you something here. I don't think that appeal is going to go anywhere.
You don't think the appeal will go anywhere?
I don't think so.
The Attorney General is convinced. He says that, look, he sees merit in some of the charges. And the reason why it's going to court. And on the grounds of appeal, listen to the language of that notice of appeal and the stay of execution. This is what the Attorney General says. I'm going to read it, at least so I don't take the matters out of... This is it, when he filed. It says that this occasioned a miscarriage of justice. This is the Attorney General speaking. Among other reasons, material errors of law and fact are apparent on the face of the record. It raises substantial and arguable grounds of law which disclose a real likelihood of success.
I've heard all of that. Okay, well, listen.
You still don't believe this?
A carpenter goes to work. His tools are hammers and chisels and things. A lawyer's tools are gowns, dressing, and language. Those are lawyer's tools. Now, and a lawyer can argue anything. So he can say all these things. We will look at the effect. And clearly, it seems every government comes and clears their people. And this government in 2 years, check how many people they have cleared. Check the value, okay, of the charges against them and what could have been recovered, even if we recovered half. We have cases where they say they are going to recover 60% or so. We haven't seen, what has happened with it. Look, my brother Martin is here. Oral, they were jumping back and forth, up and down. How does this play? Like I said, you like teaching, but I don't want to kill the cow. Okay? We cannot say we are fighting corruption when clearly there looks like, it seems like there's a trend where the government is clearing its people, and then they go on appeal, and we don't know what the appeal is going to do, all right? You can argue any side of any issue if you're a good lawyer. So for me, a lawyer's tools are his dressing and language. So composing the language to say, when the US is quoted his guy and things, it makes him look like a demigod. And then he will use it. So when you hear some of these things, look at the action. Look on the ground and see what the trend is. So for me, like I said, if there's any benefit of doubt, okay, I will give it to the judges. But it also does not look like they acted in such a way as to make everybody believe that this was clear, plain law at work. And it's sad how people are attacking Godfrey Dame. I have said that I think we should watch our prosecutors and get them to do a good job. But I think people are taking it a bit too far and personalizing this thing over the head of Godfrey Dame. All right? We need to do some of these balancing things and make sure that going forward, we will not come back and say the same things when the table is.
Is it not because he's the Attorney General?
Yes.
The buck stops with him, is it
Of
not?
course, yes. But I'm saying some of the language is a bit too personal. All right? And as we speak, okay, and I keep going back to the Ken case because the example everybody remembers. No matter what you think he has done, the botching of the prosecution is why we don't have the situation. And like I said from the beginning, Yekobisa Abrewa is in the US. The same Abrewa looked at Sedinam Tabakulo's case and said, this one is bad. Take it back. The same Abrewa looked at Ken Oforiate's case and acquitted or basically absolved him twice.
And that was on the immigration matter. That was on
An
the immigration.
judge.
I beg. I said,
A classmate.
you see this? You see? That's why I said we went to ask Abrewa, who is controlling the US courts? Okay, if this happened in Ghana, you can say whatever you want to say, but somebody who doesn't care about you, is not afraid of you, looked at the issue and said that this thing, it doesn't look like you are serious. And I'm making the point that I beg. The justices in the US, Oferata is controlling the justices in the US. Is that what you are saying? Is that what you are saying? You think they are like you people running around here doing what people
So is that what you that he attended
let me make my case.
Oforiate's son is in the US, etc.
Your son is in the US, so what?
That's why
So what?
Martin, my immigration judges in the US are not independent. No, let's correct him.
No.
Immigration judges.
What are you talking about?
They are part of the executive, the Justice Department. Who tells you an immigration
So what is your problem?
So what's the problem?
So you mean
it's not an independent.
Oferata is controlling the justice system in the US? Really?
They are part of the Justice
Let me finish my
Department.
point.
They are not immigration judges.
Oh God.
Please.
They are not independent.
Oh God.
End your point.
When you hear the name of Ken, you people, your brains break. Listen, I am making a general point, and the general point is we need to make sure we are doing things. And
No.
We are being told that when a charge sheet is defective, that defectiveness should be overlooked. Proceed. My Lord Justice Pega, in his validatory judgment, Osekwejo II and the Republic, said the provision you read relates to Act 30. However, the 1992 Constitution has raised particularity relative to charge sheet to a constitutional pedestal. Article 19, 1D. And for that matter, where particulars are defective, you cannot use evidence to cure that defect. And so if you look, Sedi had 2 appeals. When prosecution called its 6 witnesses, the prosecution said they have closed their case. A submission of no case was done. One of the issues Sedi raised right from the beginning had to do with the defectiveness of the charge. The High Court judge said, proceed and answer the charges. That submission of no case was appealed against. And if you read the notice of appeal and the grounds in respect of the submission of no case, included the fact that, included the fact that one of it clearly had to do with the defective charge. So it is in the notice of appeal.
The 2024 one?
Yes. And no, so the first appeal was August 2023. That was when she was called to open her defense. But then they raised that issue. Now, when the judgment was delivered in May 2024, if you look at the notice of appeal filed on the 9th of May 2024, in that notice is the omnibus ground. Which omnibus ground is the fact that the judgment is unreasonable, having regards to the evidence on record. All of us lawyers here seated know that once that omnibus grounds of appeal is raised, the entire proceeding is subject to review. And that is why we say appeal is by way of what? Rehearing. It means that everything that happened at the trial court, the appellate court is put in that position. Obviously, they don't have the benefit of assessing demeanors. Because the trial court is the only one that gets the opportunity to see witnesses and others. The appellate, they are just going to look at just the record without more. Okay. Now, I have heard the former Attorney General, the former persecutor, say that the notice of appeal was not brought to his attention.
Yes.
Yeah, yes.
Can you imagine? Clearly, it shows you that the guy was sleeping on the job.
Well, this is the part of the statement. He says no notice of an appeal filed by Sedinam in 2024 came to the attention of the office of the Attorney General in my tenure.
Please, hold on. I've read the statement.
And deal with the records too.
Please, I've read the statement.
The records were not also filed.
I'll deal with it. You see, Kofi, you are a lawyer. Don't do this.
Hey, Master.
Senior.
Bring me in.
Yes, you will. But my point is that as lawyers, there's a bigger standard placed on us. With the greatest of respect to you, you can't speak like Anyaba. He's a politician. He is permitted to express any opinion, anyhow. Desirable. But you, a standard is placed on you. You cannot sacrifice that standard on the altar of political expediency. Why do I say so? On the 9th of May 2024, the notice of appeal was filed at the registry of the High Court. Whose permission or duty is it to serve that notice? Sedi? 2, the point had been made that pieces of the records were even missing. Look, I have with me the decision of the Court of Appeal differently constituted. Because the Attorney General brought an application before the Court of Appeal for rectification of the record. Is that not the procedure that the rules permit when you have issues about the records, is to apply for rectification? The Attorney General applied to the Court of Appeal presided over by Justices Georgina Dacha, Amedahe, and another one, who reviewed, in fact, said these lawyers opposed the application on the grounds that the very document they claim were missing are documents that the prosecution itself disclosed to them. And so for that matter, you cannot be saying that your own document is missing from the record. Said these lawyers oppose it. The Court of Appeal looked at the two sides and came to the conclusion that regardless of the fact, your claim that the prosecution has it already, our decision is that the records ought to be done again. And those documents submitted to the Attorney General. Are you aware of that? And so what have you decided to do? Bandy misleading information to cheer up your supporters who have lost an election. Said it's not the reason why you lost your election, a devastating election. Said it's not the reason.
So, what I'm saying, that's what we mean by two lawyers never agreeing on one point. Yes, this one has a different view, the other one has another. So he has quoted his Bible, that's Kpebu, meaning that that's how he would have dealt with it, right? But he's not the judge. That's the unfortunate situation. So in the democracy, he's allowed to hold his opinion. Yes, because you see, that's the way it is. So I cannot totally say that he's so wrong. No, he's coming from a different perspective, right? Which is in the law, right? And but that's not the end. There are other people who see it differently. Now let's go straight into the case. I'm most interested in the 350 cars, and I said the moment I saw that
procured for GPRTU.
Yes, 350 cars. And
the charge was that they were inflated.
Perfect. So let's come this way. When the MPP administration took over, Oforiata renegotiated the contract. If you knew that the contract is so terrible, is so bad, the overinflation, etc., deal with it legally to abrogate, right? Because you can show fraud, etc. Deal with it. But you chose to renegotiate. So after renegotiating, how do you come back and still saddle Sedinam with the consequences of that contract? It was renegotiated. That's what Foriata did. And the Egyptian company, so I understand, they were represented by... they were represented by, what do you call it, the Marti Kpebu's company, right? Yeah. So once it's been renegotiated, it's difficult. I don't understand why you still want to hold Sedinam responsible. If they were charging Oforiata for it, then it would have been a different matter. But once you renegotiate, to renegotiate a contract, you've met a contract, it has certain prices. Then you go into it and say, no, this is too high, this. You renegotiate, then and sign. So that's a fresh contract. Then you come back and say you hold Sedinam again. I cannot understand that. Don't touch it. So that part, I disagree with Kpebu. I don't know how he's going to apply sections 31 and then section 406. No.
Renegotiation than payment was made?
Yes, by Oforiata. It's not even in 2017, no. In 2018, in 2018, more than 1 year after coming into office. So why do you go and saddle it? Remember, Sedinam didn't pay 1 cedi on it. So me, the day I heard that part, I was like, Oforiata again. Can you imagine? How do you renegotiate a contract and then go back and say you are holding the previous person responsible? Then you would find the other parts where Sticker himself came to give evidence. He's PW1.
You mean Dr. Sedinam?
Yes.
The Shayesu MP?
Yes. At that time, he was head of Maslow.
Yes.
Where he said, part of the charges were no longer relevant, etc. That is Sticker's own evidence. You see? So me, because the age is gone on appeal, as I say, you know the way I do my things, the part I'm very confident of, I'll speak clearly. The one I'm not confident, then I'll leave it for the Supreme Court to decide. So as for the basis side, to the extent that it was renegotiated, and so paid under MPP, I don't see how we can hold Sedinam. And please, let's repeat, for the avoidance of doubt, the charges are what? 78. So when I talk about these ones don't cover all. And the part where Sticker, that Stephen Amwa, came to admit that the payments were made, the money was duly used, it means that all those charges, I expect that the Attorney General will lose that side. But I'm not talking about all the 78. So I should not be understood to have covered all the 78. No, I'll speak confidently only about the ones that I fully understand. The other ones, it's good. Eduzi has better understanding of the case. So that one, I'll yield to him.